Welcome and thank you for viewing this update on the Employee Retention Credits and the Voluntary Disclosure Program. As we know, the Employee Retention Tax Credit can be a very beneficial tax credit for businesses that suffered gross receipt declines and were suspended by government orders in 2020 and 2021. But there have been some very important changes to the programs and filing deadlines. I'm Carolyn Powell, Development Director at Tronconi Seguera & Associates, and we'll get us these updates from our two experts. As you know, Tronconi Seguera & Associates is a certified public accounting and business consulting firm. Chuck Pizzino is a CPA and partner on our accounting and audit team and has over 25 years of public accounting experience. Tom Mazurek is a CPA and partner on our tax and SALT team and has over 23 years of experience. Both Tom and Chuck have headed up our COVID response team and actively follow up for new updates and changes to these programs. So I'm going to hand it over to Chuck to get us started.
Thank you, Carolyn. So today we're not going to spend a lot of time talking about the qualifications of ERTC or ERC. If you haven't yet applied for ERC, please reach out to us if you feel like you may qualify, and we certainly can take a look. There is a chance, and we're going to talk about this as part of this slide deck today, but there is a chance that the IRS is going to completely end the program and not accept any further claims after January 31st, 2024. I personally don't expect that to happen, but it certainly could. And if it does, and you're listening to this after that date, then unfortunately, the time to file claims will be over. But let's hope that doesn't happen. For those that are listening that have already filed and haven't received their credits and wondering what's going on at the IRS, or those that may have used one of those aggressive promoters or solicitors, often called ERTC mills, and you're a little bit concerned about what it might mean, if you really were eligible or not, this particular webinar is going to be especially helpful for you. So let's just backtrack to September 14th, 2023. The IRS really surprised us. On this date, they announced an immediate moratorium until at least December 31st, 2023, on processing all new ERC claims due to the number of fraudulent claims that they had received in the last 90 days prior to that date. They claim that they've processed 3.6 million claims as of that date. They had an inventory of 600,000 open ERC claims. I think it may have been higher, but that's what they publicly stated. And they publicly stated that out of those 600,000 that they had received in the last 90 days, the vast majority of them were folks that didn't qualify for ERC. So to prevent the continued inflow of fraudulent claims, they put an immediate moratorium on processing anything that was received after September 14th. If your claim, and what I mean by claim is a 941X, was properly submitted prior to that date, the IRS will continue to process those, albeit probably much slower than they had previously. But anything new is just going into a queue. So they said you can continue to submit. We've been doing that for our clients, but it's literally just sitting in queue right now at the IRS and is not being processed. And here we are, January 24th, 2024, and the IRS has not announced an end to the moratorium. So, and we really don't know when they're going to do that or how things are going to play out. But, we'll give you some information on how things could potentially play out based on what's kind of happening in Congress and at the IRS as of this point. So as I said, the IRS has continued to file claims that were submitted to the IRS prior to September 14th. They are anticipating a processing goal of about 90 to 180 days. But if your particular claim is flagged for further review or audit, it certainly can take longer. I would suggest that we're seeing significantly longer processing time at this point. So unfortunately, anyone that even submitted prior to the 14th of September is probably still waiting and has received zero communication from the IRS on status. That's pretty normal. Eventually, hopefully, they will get processed. And at this point, I still think the IRS is processing just about every claim, with the exception of if they can run some algorithms or run some some simple checks. And if you're not actually a business or you don't have employees, they probably are not going to process that at this point. But prior to September 14th, they may have been even missing those and processing them. Always keep in mind, just because the IRS has processed your ERC claim and paid you the money, doesn't mean that you aren't going to be subject to an audit at a later date, and it doesn't mean they agree with your claim. They simply were just processing them as they received them and weren't really running too many checks on those claims, due to the fact that they had 3.6 million claims they had to process. So just in, it's all completely manual. All right, so the IRS is more than aware of the solicitations everyone has been receiving from ERC mills or aggressive promoters. You've heard it on the radio, you've received the emails, you've received text messages. It's been everywhere. And many of these non-CPA promoters were suggesting that everyone qualified for all periods and not really following the letter of the law. I think that they felt that the IRS wasn't going to have the capability of really following up on these or performing a proper audit. Whatever it was that was motivating them. There's a lot of good businesses, small businesses out there that took their advice and filed claims. And now they're realizing that, maybe they actually didn't qualify. Maybe they were using incorrect assumptions around supply chain disruptions. Maybe they were looking at CDC rules around plexiglass dividers and the washing of hands and things that really had zero impact. They had an impact, but not much of one on running your business and keeping your employees employed. If you feel like you're in that bucket, the IRS has offered you two options. One is the least favored option, and it's called the special withdrawal option. We gave a webinar on this some time ago, and we're going to have a link to that on the next slide. We're not going to go into how that exactly works, but essentially, if you hadn't received your check yet, or if you had received your check or checks and hadn't cashed them, you would have an opportunity to submit a voluntary withdrawal. No harm, no foul, not cash the checks, and then move on. Most people didn't opt for that option. So the second option the IRS has allowed or is allowing is called a settlement program or a voluntary disclosure program. And Tom is going to take us through that. And that's a lot more beneficial. I can see more people jumping on that particular option. So, again, here's the link to the special withdrawal process. Our webinar was on December 12th, 2023. There's a hot link here to it. And you also can find this on our website, but welcome to listen to that again if you have interest. But this particular withdrawal process was only for those that hadn't yet received their checks or hadn't cashed those checks. And here we are. It's January 24th, but this particular slide is based on the information that we have from the IRS directly. And as of December 9th, the IRS had 1,050,000 unprocessed 941X tax returns. You'll recall that the number was 600,000 as of September 14th. So they continued to receive 941X amendment forms, and the number of unprocessed continued to grow. Now this is a net number. This might be net of what they did process during that time, and so they may have received quite a bit more than 400,000 amendment forms during that period of time. But as of December 21st, nearly 3 months after they announced the moratorium and basically the allowance to renege your claim if you chose to, only $100 million of withdrawals occurred. Now, Tom and I kind of did some math, and we're guessing, but that's probably less than 1,000 ERTC filers deciding to withdraw their claims. Now, of course, the window for those IRS allowing people to withdraw, again, was only those that had uncashed checks or hadn't received them yet. But not many people took them up on that particular offer of withdrawal. And it could also be that people just genuinely believe that they qualified based on the advice of a solicitor. Now, if you use the CPA, you're probably in great shape. But and maybe some non-CPA processors did a good job of following the rules. But we're very aware that many of the solicitors were egregiously outside the lines of what the IRS would allow. And you know, so it still may be that small businesses don't quite believe that that's them and haven't taken the time to kind of step back and say, did I really qualify for this? Again, as of today, there's no definitive timetable for ending the moratorium. So anything that was submitted after September 14th is definitely sitting in a pile still and not yet being processed. So please be patient. If you did submit an appropriate claim after that date, you're just going to have to wait for the politics and the IRS to kind of decide to lift this moratorium and get back to processing these claims. If they do end the ERTC program, we're going to talk about this in the next couple slides, on January 31st, you're still going to be okay because you got your claims in prior to that date. Okay, so here's the other thing that the IRS is finally doing. On December 6, 2023, they announced that they're sending more than 20,000 letters rejecting questionable ERC claims to combat scammers and promoters that were encouraging businesses to file claims. But the two categories of claims that they identified as not being allowed are somewhat laughable. Your entity was not in existence during the period of eligibility, or you had no paid employees during the period of eligibility. Like, why they hadn't been doing this all along, I have no idea. But this is what they're finally doing now. And so they're sending disallowance letters. Tom, these disallowance letters going to people that actually received claims or those that had filed prior to September 14th, and they're just not going to pay them?
Those who filed prior to September 14th.
Okay. So, you know, you may have been in these categories and received checks. I hope none of you are, but if you are and received checks, you would be a great candidate for filing a voluntary disclosure program, and you don't qualify for ERTC, obviously. You know, I don't know that they're doing a whole lot beyond this. We have seen evidence that they're comparing payroll submitted or qualified wages submitted with the 941X to the 941s themselves. And to the extent that any of those wages were in excess of those quarterly 941s, automatically rejecting the claim. So it does seem they were doing that for a period of time. I don't know if it was for everyone, but we certainly have seen evidence of that. All right, and last slide before I turn it over to Tom to talk about a really nice voluntary disclosure program. This is just a recap of the 20,000 letters, not a recap, okay. Okay, so these are,
They announced when they announced the voluntary disclosure program, they kind of snuck it in there that they sent another 20,000, I guess they like 20,000, new letters with proposed tax adjustments. So if you already received a credit or were approved, they're now saying, hey, we think something was wrong with that, and we're going to recapture erroneously claimed credits now.
okay.
And that's just for 2020.
All right, thank you, Tom, for clarifying that. So just a little confusion. It's another 20,000 new letters, but a different 20,000 group. So this is for tax year 2020. And I bet they're running some simple checks on information the IRS already had and noticing situations, like I said, where the 941X qualified wages exceed the original 941 wages, or maybe the fact that the EIN that was used to submit was for a business that was no longer operating, or a number of other things that they have readily at hand that they just didn't have time or weren't able to capture or identify back when they were processing these claims in 21 and 22. All right, so with that, I'm going to turn it over to Tom, and he's going to walk us through the voluntary disclosure program.
Thanks, Chuck. So as Chuck said, the IRS came up with two ways to help businesses who they felt maybe were taking advantage of by ERC mills over the past couple of years. The first one was that withdrawal program. That was very limited. That was only for people, like Chuck said, who haven't had their claims processed, they haven't received their checks or cashed them. I mean, what about the folks who already, received their refunds, quarterly checks, with interest, what about those guys? So they announced on December 21st the details of a new voluntary disclosure program, the ERC BDP, to help businesses who now want to pay back that money they received after filing claims in error. This program is open through March 22nd, 2024. It's all completely online, and it requires you to voluntarily pay back the ERC minus 20%, which I'll talk about, cooperate with any requests for the IRS for more information, and then sign a closing agreement. Just want to issue a quick warning here, because the IRS has been all over this. If you claimed and received the retention credit and you're not entitled to it, and you don't participate in the withdrawal program or the voluntary disclosure program to correct it, you risk getting audited by the IRS. They are taking this very seriously. And if you do get audited and they find that you weren't eligible, it's going to lead to substantial interest, penalties, and if you file fraudulently, potential criminal investigation and prosecution. If you willfully filed any employment tax return that fraudulently claimed retention credit, or you assisted or conspired in that conduct, you will not be exempt from criminal investigation and prosecution by taking advantage of the voluntary disclosure program. You have a whole other set of serious problems you need to deal with. So just wanted to let everybody know that BDP is not going to get you out of any criminal charges or prosecution by the IRS. At least you'll be able to return the money and take advantage of some of the different benefits of this program on the next slide. So like I said initially, you only need to repay 80% of the retention credit you received as a credit on your return or as a refund. And the IRS decided to do that because they felt that a lot of businesses were getting charged outrageous recovery percentages by these credit mills and other promoters in the neighborhood of 15 to 25%. So that money's gone. You're not getting that money back if you already paid the credit mill or whoever to help you with this claim. So the IRS said, look, we're only going to take 80% of it back. You don't have to repay any of the interest you received on your ERC refund. I mean, there was a small amount of interest on every quarterly refund check that you got, so that's a benefit. You don't have to amend your income tax return to reduce your wage expense. If you recall, as part of this, if you filed in 2022 for your ERC in 2020 or in 21, you probably already filed your income tax returns for those tax periods. And you'd have to go back and amend those returns to reduce your wage expense for what you received in ERC. They're saying you don't have to go back and amend those tax returns now. Additionally, the 20% reduction is not going to be taxable as income, which is a nice benefit. The IRS is not going to charge penalties or interest on the claimed ERC amount as long as you pay that 80% back in full by the time you return your signed closing agreement. And they're not going to audit you for employment taxes as long as you resolve it within the terms of the voluntary disclosure program. Very, very generous benefits to businesses out there who may have claimed the ERC in error or were led astray. So who's eligible for this? Essentially, anyone who applied, whether you're a business, a tax exempt organization, or a government entity, you can apply for the voluntary disclosure program for each tax period, each quarter that meets the following requirements. Your claim has been processed and paid as a refund, and you cashed or deposited that refund in the bank. You now think you're entitled to zero, and then importantly, you're not under audit, you're not being investigated criminally by the IRS, or you have not received a notice, like Chuck said, one of those 20,000 notices, indicating the IRS is intending to reverse your ERC to zero. So as long as none of those apply, you can take advantage of this voluntary disclosure program. Important to note, if you used a third-party payer to file your employment tax returns, and by third-party payer, I mean like a PEO, where you really don't have employees, the employees are part of the PEO, and they file a large employment tax return for all the companies that they have employees for, you can't take advantage of the voluntary disclosure program yourself. You have to contact a third-party payer to apply. I've talked to a few different third-party payers that we have here in Western New York, and the withdrawal process was one thing. This is going to be an even bigger headache for them, and I don't envy the position they're in when it comes to this. So, great, you're eligible, you can take advantage of these benefits. How do you apply for this? Well, the IRS has a different application form that you have to complete. Again, all of this is going to be done online through the IRS website. There's Form 15434, this application for Employee Retention Credit Voluntary Disclosure Program. I have, hot links on this slide for all these different forms. Just note, the 15434 form is a little quirky online when it comes to opening. You really need to download it and then, open it up in like an Adobe browser in order to really view it. So we'll go through the different sections of this form on the next slide. The IRS would also like you to prepare what they're calling Form SS10 PDF, which is really just a consent to extend the statute of limitations. Now that's only limited to employment taxes. You're not opening yourself up to extend the statute for income tax or any excise tax. Really, it's just for the 2020 taxable year. And like I said, it's limited to any underpayment of employment taxes related to the retention credit. So that's only for 2020. You need to ensure that you have an authorized person sign these forms, and then you follow the steps in this FAQ entitled, How do I submit my ERC VDP application package? Like I said, everything is done online, you repay online and whatnot. So this link here will take you through it. And again, you have till 11:59 p.m. on March 22nd, 2024 to take advantage of this. So let's look at the form itself. Very simple form, actually. The first three parts here, the first part, you really just your taxpayer information, your name, your EIN, your address, contact, phone numbers or emails. If you did use a third-party payer, Section 2 needs to be completed by them. So the IRS knows who they're dealing with here and what employment tax return they're looking at. And then part 3, if you're using an authorized representative to assist you with this, such as a CPA, you need to complete the power of attorney form 2848 in order for the IRS to be able to contact and communicate about your issues direct with the CPA. Part 4 is really the meat and potatoes of this application form. This is where businesses basically show what they've claimed for employee retention credits and received. You can see the first line, you have to put your form in. So essentially that's going to be your 941, your 941X, and then you report your non-refundable and your refundable ERC. And you might be asking, what does that mean? It's just kind of a technical issue. The non-refundable portion of the ERC is what reduced your tax liability to 0. So if you already filed the 941, you already paid some tax. So this portion on the 941X, there's two different boxes we had to fill out when we did the 941X. The non-refundable reduces your liability to 0, but then the refundable portion, can take your total tax liability below zero. So if you were filing a 941X, everything was refundable, so everything came back to you. So basically, you add those up, you take out the 20% credit that they're allowing you, and you show how much you're going to basically be paying back for each quarter you file the retention credit claim. And then on part 5, this is a very interesting part, and this is where I said earlier, the IRS, you need to cooperate and provide information to them. This is where they're asking you to basically tell them who are the preparers or the advisors that you use to submit this claim. So you have to give their name, the firm name, their contact information, and describe the services they provided to you in preparing this claim. It makes a lot of sense that the IRS wants this information. They're going to be able to see, in large segments, who are these preparers, and then substantially go after them and look at different claims that they filed, and hopefully find, other claims that maybe, should not have been filed, people weren't eligible for. And then the last part of the form, really, it's where you're just signing your name, your signature. If there's a representative, they're going to sign there. Like I said, very simple form for people to fill out. So essentially, once you submit your application package online, the IRS is going to verify your eligibility for the Voluntary Disclosure Program. They're going to send you a letter letting them know they received the application and whether or not they can proceed with it or it was rejected. If they can proceed, they're going to mail you this closing agreement. Like I said, you're going to need to then pay your full voluntary disclosure amount using the IRS's electronic federal tax payment system. They're suggesting, I've read in the FAQs, that if you pay at the time you apply, it'll help speed up the processing time and resolve your case more quickly. I guess I could see doing either way with that. And then obviously, like I said, you have to have an authorized person sign the closing agreement and then upload all this information to the IRS and get it in. From what I read, it looks like it's going to be about 11 days after you receive your closing agreement in the mail that you need to basically submit all of this. Once they receive your closing agreement, they're going to adjust your account. You do not need to submit amended returns. Do not re-amend your 941. So you don't need a 941X to amend your 941X. You just let it go at that point. The terms of this program cannot be appealed. If your application is rejected, you're going to get a letter explaining why and offer potential solutions. You may be able to correct an error. Maybe it was just a computational error on the form, or you didn't provide some information and you can resubmit. If they do reject and you cannot, your only option is going to be filing an amended employment tax return then. And at that point, you are going to be subjected to interest and penalties. The IRS will, let you recapture the reduction in wage expense on your income tax returns as well, as long as it's within statute. And we'll talk about what's going on with that on the next slide or two. One last thing I want to, couple of other notes that are important. If you're unable to repay this amount at the time you complete your Voluntary Disclosure Program application, you can request the IRS to consider you for an installment agreement to pay over time. Chuck, a lot of businesses got very large employment tax, ERC credits, and it may be hard for some people to return all that money at one point. So this is an option. This installment plan is an option. You would use Form 433B because essentially you have to apply and show the IRS your financial position so they know that you're essentially good for it over the next time period. However, like I said earlier, with the amended returns, you are going to pay penalties and interest if you enter an installment agreement. In fact, the IRS goes as far in the FAQs to say you should consider financing the payment if you have to. Because the penalties and interest could be substantial. And just in case people were wondering, you can't submit an offer in compromise for this. That's not on the table, as it is with other tax issues with the IRS. A couple other quick things, and this is something that actually we've talked about before. What if you filed an amended tax return to eliminate your ERC? Let's say you got a little jumpy and you were like, well, you know, you started reading about these credit mills and the IRS auditing, and you said, you know what, I'm just filing an amended return and getting rid of this. Well, technically, you're not eligible for the Voluntary Disclosure Program for any periods you amended. However, the IRS is being generous, and they're going to look at this on a case-by-case basis, which I think is fair. You know, you were trying to do the right thing, essentially. So hopefully they will look at you favorably and essentially let you into the program. And then, as with the ERC in the past, with the notices and the FAQs they've put out, there's a whole set of frequently asked questions that I've linked to here on the IRS website that will, you know, give businesses, their tax advisors, you know, additional details of how the program works and some of the information needed. So one more thing we want to talk about, and we've alluded to this January 31st thing a couple times now, Chuck. You know, there's this update that really just came out last week. You want to?
Yeah, sure. So, you know, these last two slides really apply to the businesses who have not yet filed the ERTC and yet think you may be eligible, and for whatever reason you just haven't quite gotten down to it yet. There is a proposal in Congress that would end the ERC program effective January 31st, 2024. So regardless of whether or not you're completely eligible, you will no longer be able to file 941Xs and claim the credits. It's over. They aren't going to actually vote on this until the 29th of January. So hopefully. And they may not, but if they do, it's possible that there's literally not going to be any advanced warning that they're going to vote on it on the 29th, cancel the program as of the 31st, and everyone who really needs this money and is a qualified small business and deserves this money is not going to ever be able to get it.
Yeah, essentially what happened was last week, the chairman of the House Ways and Means and the Senate Finance Committees kind of came together with this bipartisan proposal called the Tax Relief for American Families and Workers Act of 2024. Strong bipartisan support, supposedly revenue neutral. It expands the child tax credit, some R&D credits, bonus depreciation, a lot of things very favorable for businesses. But in order to pay for all this, the counter was we're cutting the ERC off on January 31st, 2024. They think that's going to save them some $70 billion that they're going to be able to use to pay for all these tax credits. Now, in addition to cutting the program off, you know, they're going to basically have some additional things to go after businesses and promoters who they feel are taking advantage of the system. They're going to extend the statute of limitations for the IRS to audit to 6 years from the time this was you filed for the credits. They're enhancing penalties for promoters that are very substantial. At the same time, though, the one thing that I like is they are considering the fact that they're extending the statute to audit for 6 years. They're also going to extend that statute to file amended income tax returns to 6 years. Because let's say something happens 4 years from now, you're out of statute on your 2020 income tax return, your retention credit gets reduced to 0, you can't go back and re-amend that return to recapture that amount of wage deduction you removed for the retention credit. So that's a good provision. I'm really happy they did that. It was just on Friday, I believe, House Ways and Means approved the measure. The House Ways and Means Committee approved the measure by a pretty substantial 40-3 margin. So now it's going to move to the House floor. And as Chuck said, the earliest that's going to happen, they're on recess apparently this week, is the week of January 29th. But there's questions as to whether that's going to be a standalone measure or it's going to be attached to other must-pass fiscal legislation, which if that happens, then this gets a lot murkier and a lot cloudier, especially if it moves over to the Senate after it's approved by the House, because it's got to be a kind of a dog or cat fight at that point to see whether or not that Senate will pass it and then move it along to the president for signature. So a lot's happening. The one thing I will say, and I think everyone who is following this or who's worked on retention credit claims will say, if you have a credit or believe you're eligible, you should definitely get this in by January 31st of 2024. Otherwise, you might be out of luck moving forward.
Yeah, so, a lot there, Tom, thank you. And, if for some reason this isn't passed and we end up on the original timeline, you would have until April 15th, 2024 to file your 2020 claims, and then until April 15th, 2025 to file your 21 claims, your 2021 claims. So there still would be plenty of time if they don't end up passing any kind of any type of early ending of the ERC program. So stay tuned. Of course, if you are a person or a business, if you are a business who hasn't yet filed ERTC, we've probably scared you to death with, the previous 25 slides of what the IRS is doing. Don't fear, as long as you're using a qualified CPA, and we're certainly still accepting new clients, and we will thoroughly look at your situation. We would thoroughly apply the rules and make sure you are 100% eligible for anything that you file. You still will have a 6-year period of time to maybe have a little stress about whether or not the IRS will choose to audit you. But if you have appropriate documentation and support and you follow the rules, you'll have nothing to fear. And I hope that's the vast majority of people that are listening. If you did choose not to use a CPA, such as ourselves or another qualified CPA, and you did use an ERC mill and you're still confused as to whether or not you filed an appropriate claim, and maybe you have a little bit of consternation about the situation, you can reach out to us. We will talk through the situation with you. We will do that for free. So we'll do initial consultation, no charge. We just want to talk to you, see what's up. If we can help you, then we can talk about what the cost might be. We also are partnering with Lippis Matthias, and they are going to be working with us for any situation where there is an IRS audit and you did get an IRS letter and potentially are subject to audit and having to pay back your claims. This is outside of these voluntary programs. We also will be able to take a look at the situation and maybe help you negotiate with the IRS in that process and come to a settlement, or maybe no payment at all. So, so I would say there's 4 categories of folks out there. Those that haven't yet filed and believe they're eligible, please reach out to us. Those that did file but haven't cashed their checks yet or haven't received them, there's some options for you. Those that have filed and received their checks and think that they may not qualify, that's the Voluntary Disclosure Program you want to take advantage of. But let us look at your situation first before you do anything and give you appropriate advice. And then those that are, I guess, in the final category, you filed, you think you qualify, the IRS has decided to audit you. The process is a little arduous, you're a little concerned. Bring us in and we'll give you some advice in that situation and work through it to your advantage.
Yeah, I mean, even if this legislation ends the ERC program on January 31st, that's just the processing, the filing of new claims. The special withdrawal process is still there until the moratorium ends, and the voluntary disclosure program is still there until March 22nd. So you still have options if you filed previously and believe that maybe you're no longer eligible. So.
Okay, so just to wrap it up, our contact information can be found at the end of the slide deck. We are here to serve. Any clients or any non-clients that want to reach out, please feel free to contact us, and we'll do everything we can to help you in your particular situation.
Thanks, everybody.
Thank you.
Thanks, everyone. Thank you for viewing this, and reach out anytime.